Americans are capable of achieving extraordinary things when they have the freedom and opportunity to do so. This is American Potential. And here's your host, Jeff Crank.
All right, well, thanks for joining us on American Potential. Hey, how would you feel if a government agency came up with a regulation for your job and then told you that you had to cover the cost to pay for it, and Congress didn't approve that regulation? Sounds like a bad idea. But in 2020, this bad idea went into effect for a certain part of the fishing industry. Herring fishermen were told they'd have to pay to have a monitor on their boat, and it would cost them on average $710 a day. Now, how many of you could afford to absorb that amount into your budget? Probably not too many. So how did we get here? Two factors. The first is the creation of the administrative state, which, if you want to hear more about that, check out our episode, which we released earlier this week with Senator Mike Lee. And the second was a landmark Supreme Court case. So back in 1984, Chevron USA Incorporated versus Natural Resources Defense Council, Inc., set legal precedents for courts to defer to the agency's reasonable interpretation, unless Congress has directly spoken about the issue. So on today's podcast, we have herring fisherman William Bright and Cause of Action Institute Counsel Ryan Mulvey, who are petitioning the U.S. Supreme Court to hear their case and also talk about the effects that this will have on the herring industry. This is an incredible story. Thank you for joining us. William, thanks for being here with us today.
Hey, thank you, Jeff. My name is William Bright. Actually, I've been fishing I started fishing in 1980. I started herring fishing in 1990, and I purchased my own vessel in 1997. This is a very important case to us going forward, because it is putting a lot of burden on us with the opportunity to maybe even expand into other fisheries. That's why we're very concerned today.
Yeah, and I understand you also, aside from that, you also own a restaurant as well. Is that right?
Yes, I'm pretty vertically integrated to the fishing business. This vessel, the retriever that catches herring, also catches squid. And that vessel actually supplies the bait for my longline vessel, which actually supplies my restaurant, which actually we sell retail, wholesale, and we actually, at the end of the day, I take the trash out and put it out. So I figure that I qualify as vertically integrated. I feel that I do have a right to speak on this topic.
Yeah, and I think it's fascinating. And one of the great things about this podcast, and I'll get to this in a minute, is why you chose to fight this battle, because a lot of people just say, oh, well, it's government regulation. I don't have the time to deal with it. We'll get to that in a minute. But you talked about how long you've been a fisherman, and how have you seen the industry change over that time that you've been in the fishing business?
Well, I've seen the whole industry change. When we first started fishing, it was almost like the Wild West. There was no rules and regulations, and we've seen these regulations just steadily grow, and with reason. And most of them are needed. But we went from very large quotas, which the government promoted us to get into this fishery. They actually financed us to get into this fishery, where the other banks would not. And what we found is that their quotas were overinflated at the time, and the quotas have constantly shrunk. Sometimes we were probably fishing herring 200 days a year on some years, and then as the quota shrunk and as the environment changes, a lot of the herring are not in the areas where they historically were.
Mm-hmm. Okay. Now, this new regulation, which I just think is incredible, when did you first find out about it, and what did you think when you heard about it?
when I first heard about the regulation, it started all the way back in probably 2013 or something about that.
Mm-hmm.
I really wasn't overly concerned because I felt that we were also participating in an observer program that was giving data. We were also participating in a study fleet program. We have vessel monitoring systems, and all this science that was come out of this said that we had a very clean fishery. So I wasn't concerned. But then as it grew, I saw the pressure mounting from the environmentalists, including Pew Foundation, that was spelling trouble for us in the future. Every meeting we went to, they were just arguing. It was just like pressure. I don't believe that National Marine Fisheries Service even wanted to institute. It was just outside pressure that kind of forced them to do this.
So was the herring industry, was it being monitored before this regulation went into effect? And do you think that monitoring was effective?
Way back in the beginning, we've had monitoring probably for 20 years now. And there's a thing called SBRM, that's Standardized Bycatch Reduction Methodology. And what that does, they rate each fishery on the amount of observer coverage they should have. And we had observer coverage because the scientific statistics say that our fishery has less than 1% bycatch. And that's actually the same as in other places in the world that does a similar fishery. We thought that we were probably going to be clear of that, but that didn't turn out to be the case.
Now, why was the herring industry, in your belief, why was it targeted to now have 100% monitoring rather than this previous regulation that they had?
Just for the record, so now National Marine Fisheries Service, I believe they dropped that to wanting 50%. When they first started, it looked like it was going to be part of an omnibus amendment that was going to be 100. And then National Marine Fisheries Service had to match part of the funding for data collection and everything, so they dropped it to 50%. We actually have probably had all along 20% observer coverage when they were paying for it. But when they decided to do industry-funded observer to match the pressure that was coming from the environmental side, that is why that happened.
So in other words, the regulators were paying for the monitoring before, and then sort of environmental groups kind of stepped in, pushed this issue, and the regulators, sort of bought it, but they've decided that the monitors have to be paid for by the vessels themselves. Is that right?
Well, the biggest problem is that the environmental groups wanted much more observer coverage, and National Marine Fisheries Service couldn't afford it. So then I remember going to the meetings, and they were quoting that they found this money. Well, you found that money in my kid's college fund. You found that money in my pension fund.
Right.
Yes, you found the money, but at what cost? That's the problem.
Yeah, they just passed it on to you and on to the consumer, by the way, right?
Right.
As well. Yeah. Are there other parts of the fishing industry that are required to have this level of monitoring?
Actually, the only other one that has that level is the multi-species in New England. And I believe right now they settled on 80 or 90% observer coverage. Mm-hmm. The scary part about this to me is that it's a small percentage right now because the quotas have been reduced so much. Quotas are only about, 5 to 10% of what they were quoting at one time, but now the quotas are slowly starting to come back. And the biggest problem would be if they can do this in this fishery, which we fish 30 days a year, that can expand into the other fisheries where we fish 200 days a year. Now the guy sitting on my vessel, supposedly collecting data, is going to bring in more a year than the guy who actually does all the maintenance on the boat and works all year round. And that's kind of hard to swallow. Yeah.
Let's talk about the monitoring real quick. And then I do want to get to Ryan too, but let's talk about the monitoring here. Like this is an actual person on the vessel that the government used to pay for. Now they're requiring the vessel itself or you to pay for this. They're there and they're monitoring. What are they monitoring? What are they looking for?
Well, most of the time, I would say in this situation, they're looking to make sure that we are harvesting something we are not, bycatch or in areas that we're not. We are not against monitoring, to be honest with you. Monitoring works for us if the monitoring is for the right reason. If it's built to gather data to use to make quotas or assessments, a lot of the previous monitors would come on there and they would take size, age, sex samples that we could use to tell the overall health of the fishery. That is totally different to help build our program to make us more sustainable than it is to put somebody on there just for enforcement issues, to watch them kind of just sitting there watching everything you do 24 hours a day and making more than your engineer in the engine room. It's kind of tough.
Yeah, and I would say, William, and I want to ask this because I'm a hunter, and I know that most people who hunt are conservationists because we want that tradition to continue. We want the species to continue. And I wanted to ask you about that. I mean, do most of the herring fishermen or most of the fishermen in general that I mean, they themselves are conservationists. Their livelihood is dependent upon there being, plenty of herring in the sea, correct?
Well, I'm just like you, Jeff. I'm also a big hunter, a big outdoorsman, but I also know whether it's herring, whether it's deer, elk, or any of the other animals that I harvest, I can only harvest so many. So it's in my best interest to do that as efficiently as possible. Yeah.
And would you say that most fishermen that are that way? I mean, certainly there are other people who maybe don't feel that way. I would think most U.S. fishermen understand that it's a resource that we have to manage and have to manage well.
Well, we consider this. It's actually, we know that this resource is owned by everybody, but it's our, we are kind of the guard on duty, and it's our responsibility to take care of it and make it sustainable. My father fished. My boys fished. They paid their way through college fishing. So for me to be selfish and not have a long-term plan, I don't know anybody in the fishery that's not taking a long-term plan. At one time, there was a lot of people in the fishery that weren't taking a long-term plan. And fishing is not for everybody. We supply food, but it's an emotional, financial roller coaster. We just had 5 really good years, and the next year you could literally produce about 20% of what you were. It's definitely not for the faint-hearted.
Yeah. I want to bring in Ryan Mulvey, Cause of Action Institute Counsel. Ryan Mulvey. Ryan, I talked a little bit. Well, first of all, what's your involvement in this case? I guess let me ask that.
Sure. Thanks, Jeff, for having me on. So my colleagues and I at Cause of Action Institute represent Bill and the other fishermen, in this case, Loper Bright Enterprises versus Raymondo. And we have been working with them for a number of years now. But we've also been involved in monitoring the industry-funded monitoring efforts of the agency back I want to say to 2016, 2017. This is not the first fishery where the Department of Commerce has tried to require industry-funded monitoring. It probably won't be the last. And we see this effort to force regulated parties to pay for agency programs when agency funds have dried up, but without any statutory authorization to do so, as a tremendous violation of our constitutional order. At the end of the day, that's what this case is really about what a bureaucratic arm of the administrative state can do without congressional authorization.
Yeah, this is really important. I mean, it extends to all areas of really our lives. If you think about it, I talked a little bit about the Chevron case, and that was pretty landmark Supreme Court case. Can you explain a little bit more about what the case is and what the effects have been of Chevron?
Yeah, sure. So that case, facts, and I think it's important to keep in mind, Congress had amended the Clean Air Act, and there was a fight between the parties and the EPA about the meaning of the term source in the statute. So there was the fight over the meaning of a word that Congress didn't define. And what the court ended up saying, what Justice Stevens said in his opinion, was that when a court receives a case and the intent of Congress in passing a law is clear, then that ends the matter. But when there's ambiguity or silence, or there's been a gap intentionally left by Congress in a statute, then what the court should do is defer to the agency's interpretation of the statute, to give it deference. And so that's where we get this phrase Chevron deference. When you have a law that seems ambiguous, you defer to the agency's interpretation. Well, the problem with that has been that courts, for a variety of reasons, rather than really trying to understand whether Congress has expressed its intent or whether a statute really is ambiguous, just decides to defer to the agency. Right? If there's a fight over meaning, the easier thing to do is to just say, well, the agency has the technical expertise here. We're just going to accept what they say as long as it's reasonable. Right? So that's the second. And there has to be a permissible construction of the statute that the agency is presenting. But for all intents and purposes, agencies have gotten a free pass. And it has become, over the decades, very difficult to challenge agency regulations because of this deferential standard. At the heart of our fight with Chevron is a concern that the doctrine really displaces the proper role of the judiciary, of what courts are supposed to be doing. Courts, in our view, are supposed to tell us what the law says, like what it means. Congress writes the law, and the courts tell us what the law says and resolves disputes under the law. What Chevron has led to is administrative agencies, the administrative state, being able to take laws and effectively legislate on their own through interpretation and then receive deference from the courts. It's the executive not merely executing the law, but elaborating upon the law. And this particular case is a great example of that, because we're not really talking about, I mentioned the facts of the original Chevron case were about the definition of the word source. That's not really the kind of fight we have here. Here we have a fight over the authority of the agency to require regulated parties to pay for something, right? To fund an agency program when appropriations have run out. And in a real way, the agency's interpretation of the statute here, the Magnuson-Stevens Act, in attempting to require industry funding, is the agency aggrandizing power to itself. It's saying, Congress hasn't given us enough money, but we're going to get around that by simply forcing the regulated entities to pay for it instead. And that's just offensive to our constitutional order. And it gets wrong the role of the agency in executing the law, and the reliance on Chevron gets the role of the court wrong.
So how do you feel what are our chances? I mean, this has a great import, I think, not only on this case, but, this would be precedent, I think, that could be followed for forever. if and it seems like is your argument that the Chevron decision was wrongly decided, or it's been wrongly interpreted by the agencies?
So our principal argument in trying to get the Supreme Court to accept the case, our principal argument is that the agency has misread the Magnuson-Stevens Act. So before you even get to Chevron, there's a problem here because we don't think the statute authorizes what the agency is trying to do with industry funding. As far as Chevron is concerned, we are asking the court, if they take the case, to overrule it, to overturn Chevron, and to tell courts, you can't have this sort of deferential regime. You need to be interpreting the law yourself You need to use your full toolbox of statutory tools of statutory interpretation, and you need to figure out the legal questions yourself. That's your job, court. Alternatively, we're asking them to give a little bit of clarification to Chevron as applied here. You mentioned that, in all honesty, it's difficult to get the court to hear a case. Most petitions are not accepted, but we're optimistic because there has definitely been, at least at the Supreme Court, what seems like a distancing from Chevron. We've had a couple of cases that implicate Chevron that have been accepted by the court in the past few years, and rather than grapple with the continued relevance of Chevron or whether it should still be the law of the land, the court has instead developed what it has come to be known as the major questions doctrine. But I think there's definitely, we've reached a tipping point where the court seems poised to want to act on it with the right case. The scholarship in the legal academy is increasingly critical. There are some particular members of the court who are definitely eager to see Chevron go away. And there's a lot of confusion among the courts, among the circuit courts, on how Chevron is even supposed to really work. And that's really bad for rule of law purposes when you have such an important precedent that has reached such a confused state. So we're optimistic, cautiously, but you're right to point out that not a lot of cases are accepted. But I think this one, if it is taken and we were to win, the consequences would be profound for the future of the administrative state.
Yeah. So, and often the Supreme Court does take cases when circuit courts are divided on it. Is that the case here? Do you have? Yeah, it sounds like you do have circuit courts that have different views of this law.
So I think there's a couple of different forms of splits among the courts. There's not a split in the traditional sense, meaning one circuit has said this is allowed, and another circuit has said no, industry funding isn't allowed. But there have been two other types of splits. So in our case, the district court ruled that the Magnuson-Stevens Act was not ambiguous at all, like we were arguing, and in fact was clear that the agency was given authority to require industry funding. Now, when we appealed that at the D.C. Circuit, we got two more views of the situation. The majority of the panel, two of the three judges, agreed with us that there was ambiguity. So they disagreed with the district court and said, no, the statute is ambiguous, but this is a reasonable interpretation of the statute. The dissent that we had at the circuit court, Judge Walker, he said, no, the statute's not ambiguous at all. The district court was right about the lack of ambiguity. It was just wrong about the conclusion. It's unambiguous that the agency doesn't have the authority to require industry funding. So there we had the same legal doctrine applied by four different judges, and they all reached different interpretations. So that's a real split that speaks to the confusion of how Chevron is supposed to be applied.
Yeah.
There's another, real quick, I'll just mention another case in the First Circuit that's also challenging the same regulation. And there, the court just came out with its opinion last week, and they said, well, we're going to apply Chevron, but we're not even going to use this two-step paradigm that all the courts accept. It doesn't really matter whether it's ambiguous or a reasonable interpretation. It just seems to us that this is permitted. So there you have another sort of split that even further highlights the confusion among the circuit courts and the lack of uniformity in how a legal principle is supposed to be applied.
Yeah. Now, what's the timeline here? You're petitioning the Supreme Court now to hear the case. Is that right?
Yeah. So we are fully briefed. We've had tremendous amicus support, friends of the court, 14 amicus briefs filed by 39 different organizations, individuals, and states. That includes a brief by 18 state attorneys general, all of them wanting the court to take the case. It's been fully briefed. The government filed an opposition. We filed our reply. It's been distributed to the justices, and it's scheduled for conference on the 24th of March. So that is that's the end of this week as we're recording. That could be, the court could either decide to take the case, it could deny the case, or it could do what's called a relisting and say we're going to consider this at a future date at another conference. And, that could happen multiple times. A relisting, in the minds of most Supreme Court watchers, suggests that the court is seriously considering it. There may be some disagreement between the justices as to whether the case should be accepted. So a relisting is like a next best outcome after the petition being granted. But we'll see. There could be big developments by the end of the week.
Right. Okay. So, William, the regulation itself was supposed to go into effect in 2020, but because of COVID, you haven't had to pay for a monitor yet because they waived coverage. But how will this affect you if the Supreme Court doesn't take the case?
To be honest with you, Jeff, right now, it's only a small part of our fishery is the herring. The biggest factor of the precedent that it sets going forward is, with this omnibus amendment, they can up it from 50 back to 100%. They can also move that into other fisheries. That's the biggest thing going forward, because we're kind of on the leading edge of this confrontation with them, because there's nobody in the fishing business that isn't watching this and wondering if this isn't going to be our future going forward. They have to pay for it. I mean, just like what's next? We have to make farmers pay for observers just to see how much pesticides. We just went through a pandemic where food was really hard to come from. You would think that we would look at this like we actually supply food, and how can we keep these guys in business? Not about how much burden can we put on them, and see how they can survive.
Yeah. Well, this is a really, really important case. I do have to ask this, William. I kind of alluded to this at the beginning, but when something like this happens and a government agency steps in and does this, a lot of people just say, well, I'm going to keep my nose down and my head down and just going to keep fishing and doing my business. But you seem to have decided that this was a fight worth fighting. What made you want to do that, and what drives you to make sure that you see this through?
Well, what drove me, to be honest with you, I just think it was unfair. I mean, we deal with a lot of regulations, and a lot of the regulations are not based on science. We like regulations that are based in science. We try to be a very efficient fishery. And I think part of our problem is that we're so efficient that we've drawn a lot of attention from the environmentalists and stuff. But we produce protein. So my way of thinking is the faster we can go out there and produce this protein and get back with a less bycatch and with a less burning carbon fuel or whatever, the better off we all are as an environment. So I'm really concerned going forward. But this is one that I could just see that it have a real domino effect, not just me, everybody around it. A lot of my colleagues feel the same way, but just didn't want to jump on the bandwagon or lead it like I am.
Yeah, well, it takes courage to do that. And I thank you for that courage, because this isn't just, as you pointed out, it isn't just herring fishing. It isn't just fishing. This has implications throughout really every sector of America. If agencies can just come in here and impose a self-monitoring, requirement without Congress being clear on that. And so that's what you're asking in doing this. How can folks, if they want to know more about this case or how they can help, is there a way that they can do that? And I guess I'd ask that to both to William and to Ryan.
Yeah. So if your listeners want to go to causeofaction.org, altogether, causeofaction.org. The first thing that they'll see on the page is a picture of one of the fishing boats, one of our clients' fishing boats in this case, heading out into the water. And if they click on the Learn More button, there's a really great video about this case and the story of our fishermen, Bill and Stephen and Wayne. So I would encourage them to check that out. And then in terms of what they can do more generally, I mean, if you own a small business and you're regulated, or if you're just an interested citizen, people should comment when agencies engage in notice and comment rulemaking. When they put out a proposed regulation and they invite the public to comment, that's our opportunity to fight back. Ultimately, it needs to be hashed out in the courts. But during the administrative process, during that notice and comment rulemaking, people should write in and let their voice be heard and tell regulators, this is wrong. This is overstepping the bounds of your authority. This is going to have a tremendous economic impact. If more people do that, that's one small step towards checking the administrative state.
Yeah, it certainly is. By the way, Cause of Action is a great organization. Just take a minute here and tell us what Cause of Action Institute does.
So we're a 501c3 organization. We're an oversight group. We do some third-party litigation advocating for economic freedom, economic rights, and individual opportunity, and really trying to check instances of overreach. Like in this case. And we have also done a lot of oversight work, legal investigations into cronyism and instances of abuse at agencies, and sort of leveraging the power of the Freedom of Information Act. But at the end of the day, we're about educating people about the dangers of the administrative state and the benefits of a free and a prosperous society that's secured with economic freedom and individual opportunity.
Well, Ryan, thank you for what you do and what Cause of Action does. It's incredible work, and there's lots of legal work on the other side on some of these environmental groups and others that are out there. So thank you for all the great work that you do. And William, thank you for, this is what this show is about, people who meet these government barriers and decide, I'm just not going to accept this as the way that I'll be treated by my government. And they stand up and they fight back. And thankfully, you have partners like Cause of Action that are helping you in this fight. But this is really important for people to understand. There's lots, and I'll just say this, you may not agree with this, but there's lots of herring fishermen. I'm sure there's lots of fishermen in general, but not everybody has the courage to stand up like you did, William. And I want to thank you for that, because you're fighting for them, but you're also fighting for every American. So thanks for doing that. And I appreciate you both joining me today.
Thank you.
Thanks, Jeff.
Yeah. Okay. So if you'd like to get connected with Americans for Prosperity, send me an email, jeff@americanpotential.com. If you've got any thoughts about this episode, follow us on Facebook, Twitter, and YouTube, americanpotential.com. You can go there and you can hit the share your story section and tell us about other stories, just like William's, where people are fighting to fighting a government barrier, trying to break that barrier. Thanks for listening to American Potential.
Thank you for listening to American Potential. You may listen to more stories from Americans working every day to expand freedom and opportunity in their communities by visiting AmericanPotential.com.